Okay, so you're charged with non-payment of your council tax, being that you are a person liable for council tax under the Local Government Finance Act 1992.
With respect, sir, I don't wish to get into any of that right now. For now, all I need to know, sir, is where is the summons for me to appear here today?
You were sent a copy of the summons in the post some time ago.
Well, that summons, sir, states the date of hearing as 13th July 2010 at 9:30 a.m. and it's the 29th July today, sir.
Yes, the court also sent you a letter explaining that the hearing had been adjourned until today.
I see. So just to make it clear, are you saying that the summons is the one previously sent and signed by B. Tannern?
Yes.
And that the complaint made against the person is that Mr. McFly, being a person subject to council tax, has not paid the amount shown. Would that be accurate, sir?
Yes.
Okay, great. That makes things clear. I'd like to now ask, sir, who is B. Tannern?
They are a clerk to the justices.
Thanks. Then I move to have this hearing adjourned, because it is my understanding that according to Part 2 of Section 123 of the Magistrates Court Act 1980 I have been misled, because Section 51 of the same Act, which I'd like to present to the court in a moment, states that summons may be issued by a Justice of the Peace. Section 51. Issue of summons on complaint. Where a complaint relating to a person is made to a Justice of the Peace, the Justice of the Peace may issue a summons to the person requiring him to appear before a magistrate's court to answer to the complaint. Section 123, Part 2, 2. If it appears to a magistrate's court that any variance between a summons or warrant and the evidence adduced on behalf of the prosecutor or complainant is such that the defendant has been misled by the variance, the court shall, on the application of the defendant, adjourn the hearing. As you have just heard, B. Tannern is not a Justice of the Peace, and I'm therefore making application that I have been misled, and this hearing should be adjourned until such time as a valid and lawful summons has been sent to me.
No, we will continue. I'm satisfied the summons is valid, and you have accepted it.
I accept your offer to continue, conditional upon you providing an explanation of how a clerk to the justices can issue a summons. In addition, sir, I must point out that the signature on the summons does not look like a wet signature. It looks rather more like a scanned signature which has been placed on the document. It would appear to me, sir, this summons has been issued by Hill Valley Council themselves, and not by this court.
Well, I'm happy, and I'm the judge, and so this will continue.
I accept your offer to continue, conditional upon you to providing a sworn statement, under penalties of perjury, that a clerk to the justice can sign a summons, and that this summons is valid. I have pre-written this statement for your convenience, and would like you to read it, understand it, and sign and date it.
Oh, fine. Send it up here to sign.
Now, is there an original charging instrument in the court today for my inspection, please?
What do you need this for? I don't know what you mean.
I wish to see the original charging instrument that supports the plaintiff's claims and thus invokes the court's jurisdiction. Does anyone here have an original charging instrument or accusatory instrument or a claim against the defendant?
I will read it to you.
With respect, sir, I don't want you to read it to me. I wish to see it for myself and inspect it. I believe this is a reasonable request, but if the court cannot, or is not willing to show it to me, then let the record show that I have respectfully asked and been refused remedy.
Fine. What's that going to prove?
That I'm being denied my potential remedy, sir.
Fine. Here you go.
Are these the originals or copies?
Copies are fine.
Is it not true the copies are just hearsay evidence?
You can read the copies.
Is this the only instrument in the record, public or private, which is bringing this matter forward, and are you relying upon this instrument to invoke jurisdiction and authority in this matter?
Yes.
So you are telling me that this whole proceeding is moving forward without anybody's original signature on any document before this court? Does it not appear that you have taken on the assumption and presumption of having been extended a commercial energy without any security on file in order to activate or move this court?
Yes, this is acceptable. The court is happy to continue.
With all due respect, sir, who is moving this court?
I'm moving the court. I'm the judge.
I respectfully request the court causes the original charging instrument to come forward for my inspection.
Okay, here it is.
Thank you, sir.